If you are watching this video right now, stop everything you are doing because what I am about to tell you will directly affect your life, your family, and your future in America. A massive new immigration law has just been passed in the United States, and I'm not exaggerating when I say that 2026 will change everything for millions of people around the world. This is not a rumor. This is not speculation. This is federal law that has been signed and will be implemented starting next year. Right now, immigration attorneys across the country are scrambling to understand every provision of this law. Families are worried, students are confused, workers are panicking, and the worst part is that most people have no idea what is actually happening or how it will affect them personally. That is exactly why I created this video. Because in the next few minutes, I'm going to break down everything you need to know in plain, simple language that anyone can understand. But here is what I need from you. I need you to watch this entire video from start to finish. Do not skip ahead. Do not click away, because missing even one detail could mean the difference between keeping your status and losing everything you have worked for. I know that sounds dramatic, but by the end of this video, you will understand exactly why I am saying this. Let me tell you who needs to pay attention right now. If you are a green card holder, this law affects you. If you are on an H1B visa, this law affects you. If you are an international student on an F1 visa, this law affects you. If you have family members waiting in the immigration backlog, this law affects them. If you are planning to sponsor a relative, if you are hoping to apply for citizenship, if you are currently in the middle of any immigration process whatsoever, then what happens in 2026 will reshape your entire journey. Now, I want to be very clear about something before we go any further. There is a lot of misinformation spreading online right now. People are making claims that are simply not true. Some are saying the borders are closing completely. Others are saying all green cards are being canceled. None of that is accurate, and I refuse to be one of those creators who spreads fear without facts. What I am going to give you today is the truth, the complete picture, and most importantly, the exact steps you need to take to protect yourself. So what exactly happened? Let me explain this in a way that makes sense. In the United States, immigration is controlled by federal law. This means that any major changes to how visas work, how green cards are processed, or how enforcement is handled must go through Congress and be signed by the president. This is different from executive orders or policy memos, which can be changed easily by any administration. When an actual law passes, it becomes permanent. It becomes the foundation of how immigration works in this country until another law is passed to change it. This new immigration law went through the entire legislative process. It was introduced as a bill, it was debated in committees, it was voted on by both the House of Representatives and the Senate, and then it was signed into law by the president. This is not something that can be reversed with a stroke of a pen. This is binding federal legislation that will govern immigration for years to come. Why does this matter so much? Because the last time we saw immigration reform of this magnitude was over a decade ago. Previous attempts at comprehensive immigration reform failed repeatedly. Bills died in Congress. Proposals were rejected. Nothing moved forward. But this time, it actually passed. And that alone tells you how significant this moment is. The law addresses multiple aspects of the immigration system at the same time. We are not talking about a small change to one visa category. We are talking about green card allocation, visa processing procedures, enforcement mechanisms, employer compliance requirements, family sponsorship rules, and much more. Every corner of the immigration system is being touched by this legislation. Now, here is where things get interesting. The law does not go into full effect immediately. Implementation will happen in phases throughout 2026. Some provisions kick in during the first quarter of the year. Others will not be fully operational until the second half. This phased rollout is actually very important because it gives you a window of opportunity. If you understand what is coming and when, you can make strategic decisions about your own case. Think about it this way. If you know that requirements for a certain visa category are going to become stricter in 6 months, you might want to file your application now while the current rules still apply. If you know that fees are increasing significantly, you might want to submit your paperwork before those new fees take effect. Timing matters more than ever, and the people who pay attention to these details are the ones who will come out ahead. I have seen too many people get caught off guard by immigration changes because they were not paying attention. They assumed everything would stay the same. They waited too long to act, and by the time they realized what was happening, it was too late. I do not want that to happen to you. That is why I am giving you this information now, before the changes take effect, so you have time to prepare. In the next part of this video, I am going to break down the specific changes that are coming. We will look at what is happening with green cards, what is changing for employment-based visas, how family sponsorship is being affected, and what new enforcement measures are being put in place. I will explain each change clearly and tell you exactly who it impacts. And then most importantly, I will give you a concrete action plan so you know exactly what to do next. But before we get into those details, I want you to do something for me. Take a deep breath. I know this information can feel overwhelming. I know it can be scary when the rules are changing and you do not know what it means for your future. But knowledge is power. The fact that you are here watching this video, learning about these changes, puts you ahead of millions of people who have no idea what is coming. You are taking control of your situation, and that is exactly what you need to do. Now let us get into the specific changes that are coming, because this is where it really matters for your individual situation. I am going to break this down category by category so you can find exactly what applies to you. Let us start with green cards, because this is where some of the biggest changes are happening. The new law fundamentally restructures how employment-based green cards are allocated. For years, the system has operated on a first-come, first-served basis within each preference category. People filed their applications, waited in line, and eventually their priority date became current. That system is not disappearing entirely, but it is being transformed in ways that will create clear winners and losers. The most significant change is the introduction of a merit-based point system for employment-based immigration. Under this new framework, applicants will be assigned scores based on several factors. Your education level matters. A doctoral degree scores higher than a master's degree, which scores higher than a bachelor's degree. Your field of study matters. STEM fields like science, technology, engineering, and mathematics receive bonus points. Your work experience matters. More years in a specialized occupation means a higher score. Your English proficiency matters. Demonstrating strong language skills adds points to your total. Your age matters. Younger applicants within prime working years receive more favorable scoring. And whether you have a job offer in a high-demand field matters significantly. What does this mean in practical terms? It means that two people applying for the same green card category will no longer be treated equally just because they filed on the same date. The person with the higher point score will receive priority processing. They will move through the system faster. They will get their green card sooner. Meanwhile, the person with the lower score could wait significantly longer, even if they filed their application first. Now, I want you to think about what this means for different types of applicants. If you are a software engineer with a master's degree from a top university, strong English skills, and a job offer from a major tech company, this new system probably benefits you. You will score well on multiple factors, and your application will be prioritized accordingly. But if you are a skilled worker without an advanced degree, working in a field that is not considered high demand, the path just got harder. You are competing against people who score higher, and your wait time could extend significantly. This is what I mean when I say there will be winners and losers. The new system is designed to prioritize certain types of immigrants over others. Whether you agree with that approach or not, it is now the law, and you need to understand where you stand within it. The changes to visa categories go beyond just the point system. H-1B specialty occupation visas are seeing new wage requirements. Employers will need to pay higher minimum salaries to sponsor foreign workers. The idea behind this is to prevent companies from using the H-1B program to hire cheaper foreign labor instead of American workers. But the practical effect is that some positions that previously qualified for H-1B sponsorship may no longer meet the new wage thresholds. Employers might decide it is not worth the cost. Job offers could be rescinded. Opportunities could disappear. H-4 dependent visas, which are held by spouses of H-1B workers, are facing restrictions on employment authorization. Many H-4 visa holders currently have the ability to work in the United States, providing crucial income for their families. Under the new rules, obtaining and maintaining that work authorization becomes more difficult. There are additional requirements, additional documentation, and additional hurdles to clear. For international students on F1 visas, the changes are particularly important to understand. Optional practical training, known as OPT, allows students to work in the United States after graduation. STEM students currently receive extended OPT periods of up to 3 years. The new law is tightening the requirements for who qualifies for these extensions. Non-STEM students may see their OPT periods shortened. The bridge from student status to work status is becoming narrower, and not everyone will make it across. Now, let us talk about family-based immigration, because millions of people are affected by these changes. The law maintains the immediate relative category for spouses, minor children, and parents of United States citizens. These categories remain uncapped, meaning there is no annual limit on how many people can receive green cards through these relationships. That is the good news. The concerning news is what happens to other family preference categories. The F2A category, which covers spouses and unmarried children of permanent residents, is actually receiving a larger allocation of visas. This could speed up processing for this group. But the F3 category for married adult children of citizens and the F4 category for siblings of citizens are seeing reduced allocations. If you are in one of these categories, your wait time is likely to increase. Backlogs that were already measured in years could extend even further. The law also increases financial requirements for sponsors. Currently, sponsors must demonstrate income at 125% of the federal poverty guidelines. The new thresholds are substantially higher. This means that some citizens and permanent residents who want to bring family members to the United States may not qualify financially. They will need higher incomes, more assets, or additional joint sponsors to meet the requirements. I know this is a lot of information to process, but I want you to understand the full picture because that is the only way you can make informed decisions about your own situation. The changes are real, the impact is significant, and pretending otherwise does not help anyone. Here is something else you need to know. The law increases fees for almost every type of immigration application. We are not talking about small increases. Some categories are seeing fee jumps of 30 to 50%. If you are planning to file an application in 2026, the cost could be substantially higher than it would be today. This affects everything from work permits to green card applications to citizenship petitions. The financial barrier to immigration is getting higher. But there is also a new option being introduced called Premium Processing Plus. For certain application types, you can pay an additional fee to have your case processed within 15 business days. This creates a two-tier system where people who can afford to pay more receive faster service. Some see this as fair because it generates revenue for the immigration system. Others see it as creating inequality, where wealth determines how quickly you can achieve your immigration goals. In the next section, I'm going to explain what this law means for people who already have green cards, how enforcement is changing, and what the overall system will look like in 2026. These details are crucial for understanding the complete picture. If you already have a green card, you might be wondering whether any of this affects you. The short answer is yes, but probably not in the way you fear. Let me explain exactly what is changing for current permanent residents. First, and most importantly, this law does not retroactively cancel anyone's green card. If you are a lawful permanent resident right now, you remain a lawful permanent resident. Your status is protected. Nobody is coming to take your green card away simply because a new law passed. I want to be absolutely clear about this because I have seen panic spreading online with people claiming that green cards are being revoked. That is false. Do not believe it. However, the law does change how green card holders need to maintain their status going forward. The requirements are becoming more formalized and more strictly enforced. Let me give you the specific details. Travel outside the United States is where many green card holders could run into problems. Under the new rules, if you are absent from the country for more than 6 months in any 12-month period, your case will be flagged for automatic review. This does not mean your green card is canceled. It means immigration officers will take a closer look at whether you are actually maintaining your permanent residence in the United States or whether you have abandoned it. If you are absent for more than 1 year without obtaining a reentry permit beforehand, the law creates a presumption of abandonment. This is more restrictive than the previous standard, which allowed for more flexibility in proving your intent to maintain residence. Under the old system, you could present evidence showing you still considered the United States your home, even after extended absences. Under the new system, the burden is heavier and the scrutiny is greater. What does this mean practically? If you are a green card holder who travels frequently for work, who has family obligations overseas, or who splits time between countries, you need to be more careful. You need to document your ties to the United States more thoroughly. You need to maintain evidence of your job, your home, your bank accounts, your community connections, and everything else that demonstrates this is where you live permanently. The law also introduces new reporting requirements. If you change your address, you must update uscis within 10 days. This requirement existed before, but enforcement is becoming stricter. If you change employers in certain circumstances, there may be reporting obligations. If you have any criminal arrests, even if charges are dismissed, there are notification requirements. Now, let me address the enforcement side of this law, because it represents a major shift in how the immigration system operates. The Department of Homeland Security is receiving expanded authority for worksite enforcement. This means more investigations into employers who hire foreign workers. It means more audits of I-9 forms. It means larger penalties for companies that violate immigration rules. For workers, this creates an environment where your employer is under more pressure to verify your status and maintain compliance. Any inconsistencies in your documentation could trigger problems, not just for the company, but for you personally. The law also expands expedited removal authority. This gives immigration officers more power to quickly remove individuals who are determined to be in the country unlawfully. It increases resources for fraud investigations. It grants broader powers to revoke previously approved applications if questions arise about eligibility. I want to pause here and address some of the misinformation directly, because it is important to separate fact from fiction. This law does not ban all immigration to the United States. Immigration continues. Green cards continue to be issued. Visas continue to be processed. The system is not shutting down. What is changing is the rules, the priorities, and the requirements. This law does not make naturalization impossible. You can still apply for citizenship if you meet the eligibility requirements. In fact, for certain categories, like military service members and victims of specific crimes, naturalization timelines are actually being accelerated. This law does not eliminate family-based immigration. Families will still be reunited. The categories still exist. What is changing is the allocation of visas among categories and the financial requirements for sponsors. Some family categories will see faster processing. Others will see longer waits. But family immigration is not ending. This law does not impose retroactive punishment for following the rules that existed when you took an action. If you complied with the requirements that were in place at the time, you cannot be penalized for not meeting new requirements that did not exist yet. Legal protections against retroactive punishment still apply. The reason I am emphasizing these points is because fear-based misinformation leads to bad decisions. People panic. They make hasty choices. They fall victim to scammers who promise solutions that do not exist. I want you to be informed, not afraid. I want you to take action based on facts, not rumors. So, what should you actually do right now? Let me give you a concrete action plan that you can start implementing immediately. Step 1 is to rely only on official sources for information. Bookmark the USCIS website. Check the Department of State's travel website. When regulations are published, they will appear in the Federal Register. When policies change, official announcements will be posted on government websites. Do not trust random social media posts. Do not believe everything you read in comment sections. Verify information before acting on it. Step 2 is to get your documents in order immediately. Check your passport expiration date. Check your green card expiration date. Make sure your address is current with USCIS. Gather all your immigration documents and keep them organized and accessible. If anything is expiring in 2026, start the renewal process now rather than waiting until the last minute. Step 3 is to monitor your pending applications closely. If you have anything in process with USCIS, check your case status regularly. Respond to any request for evidence immediately and completely. Do not miss deadlines for required filings. Set up email and text notifications so you receive updates about your case. Step 4, and this is critical, is to consult with a qualified immigration attorney if your situation has any complexity whatsoever. The stakes are higher now. The requirements are stricter. The consequences of mistakes are more severe. This is not the time to navigate complicated immigration situations on your own. I want to end this video by speaking to you directly, person to person. If you are feeling overwhelmed right now, if you are anxious about your future, if you are scared about what these changes mean for you and your family, I understand. Those feelings are completely valid. Immigration is not just paperwork and applications. It is your life. It is your dreams. It is everything you have worked for. When the rules change dramatically, it shakes your sense of security. I get it. But here is what I need you to remember. Change does not automatically mean disaster. Yes, this law creates new challenges. Yes, some pathways are becoming harder. But the immigration system is not ending. Thousands of people will still receive green cards in 2026. Families will still reunite. Dreams will still come true. What matters most is how you respond. The people who succeed in navigating immigration are not the ones who never face obstacles. They are the ones who stay informed, stay prepared, and take action when it matters. You are already doing that by watching this video. You are ahead of millions of people who have no idea what is coming. Use that advantage. Looking ahead, implementation will roll out gradually throughout 2026. Court challenges may delay certain provisions. Regulations will be refined. The system will stabilize over time. But right now, in this moment, preparation is everything. If this video helped you understand what is happening and what to do next, hit the like button and subscribe to US Policy Brief. I will be covering every update, every change, and every development as this law takes effect. Turn on notifications so you never miss critical information. Share this video with your family and friends who need to know. Drop a comment telling me your situation and what questions you still have. My name is Fernando. This is US Policy Brief. Stay informed, stay strong, and I will see you in the next update.